बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूवर्स, मैं हूं मलिक फ़याज़ अहमद वाड, एडवोकेट हाई कोर्ट, और आप देख रहे हैं मेरा यूट्यूब चैनल। मेरे आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें और घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके और आप इससे फ़ायदा हासिल कर सकें। ख़ासकर ये मेरे बार के और मुल्क के जूनियर वकील हैं उनके लिए है जो जुडिशरी की तैयारी कर रहे हैं। तो ये मेरी पिछले साबका तमाम वीडियोस जुडिशरी एग्ज़ामिनेशन के हवाले से बहुत ही अहम वीडियोस हैं। तो आप सब ये अगर देख लेंगे तो आपको मैंने तो कोशिश की है आपको समझाने की, लेकिन आप सुनेंगे तो आपको समझ आएगी। आज शुरू करते हैं प्यारे व्यूअर्स, सेक्शन 265 ए। ये चैप्टर है ट्रायल बिफोर हाई कोर्ट्स एंड कोर्ट्स ऑफ सेशन। सेक्शन 265 ए, ट्रायल बिफोर कोर्ट ऑफ सेशन टू बी कंडक्टेड बाय पब्लिक प्रोसिक्यूटर इन एवरी ट्रायल बिफोर ए कोर्ट ऑफ सेशन initiated upon a public report the prosecutor shall be conducted by the public prosecutor। आगे आ जाता है जनाब, क्या है 265 बी। 265 बी, प्रोसीजर इन केसेस टेरिबल बाय हाई कोर्ट्स एंड कोर्ट्स ऑफ सेशन। द फॉलोइंग प्रोसीजर shall be observed by the high courts and the court of session in the trial of cases by triable by the said courts। सेक्शन 265 सी, supply of statements and documents to the accused in all cases। Number 1, in all cases situated upon police report, copies of the following documents shall be supplied free of cost to the accused not later than 7 days before the commencement of the trial, namely। जितने भी अक्यूज़ड होते हैं उनको जो ट्रायल होता है, ट्रायल की जो नकूल होती हैं कापियाँ, तो फ्री ऑफ कास्ट कीमत के बगैर दी जाती हैं अक्यूज़ड को। ए, द फर्स्ट इंफॉर्मेशन रिपोर्ट होती है, द पुलिस रिपोर्ट होती है, द स्टेटमेंट्स ऑफ ऑल विटनेसेस रिकॉर्डेड अंडर सेक्शन 161 एंड 164 होती हैं, एंड द इंस्पेक्शन नोट रिकॉर्डेड बाय एन इन्वेस्टिगेशन ऑफिसर ऑन द फर्स्ट विजिट टू द प्लेस ऑफ अकरेंस, एंड द नोट रिकॉर्डेड बाय हिम ऑन रिकवरीज मेड इफ एनी। अगर कोई रिकवरीज होती हैं तो वो भी सारी चीज़ें वक़ुआ के दिन से जितनी भी रिपोर्ट्स होती हैं वो सारी मुलज़िम को दी जाती है। प्रोवाइडेड दैट इफ़ एनी पार्ट ऑफ स्टेटमेंट रिकॉर्डेड अंडर सेक्शन 161 और 164 इज सच दैट इट्स इन disclosure to the accused would be an expedient in the public interest, such part of the statement shall be excluded from the copy of the statements finished to the accused। Number 2, in all cases instituted upon a complainant in writing। Number 2, A, the complainant shall 1, state in the petition of complaint the substance of the accusation, the names of his witnesses, and the gist of evidence which he is likely to adduce at the trial, and number 2, within 3 days of the order of the court under section 204 for issue of process to the accused, file in the court for supply to the accused को फाइल सप्लाई की जाती है as many copies of the complainant, और बहुत सारी कापीज जो है कंप्लेनेंट शिकायत कुनिंदा and any other documents which he has filled with जो वो दायर करता है कोई भी डॉक्यूमेंट्स with his complaint as अपनी कंप्लेंट के साथ द नंबर ऑफ द अक्यूज्ड एंड तमाम जितने भी मुलजमान होते हैं उन तमाम को उसकी एक एक कापी मुहैया की जाती है. B copies of the complainant and any other documents which the complainant has filled therewith and the statements under section 200 or section 202 shall be supplied free of cost. किसी भी कीमत के बगैर जो है ना वो मुलजिम को तमाम डॉक्यूमेंट्स पूरी फाइल जो कोर्ट में होती है वो कीमत के बगैर फराहम की जाती है मुलजिम को. टू द अक्यूज्ड नॉट लेटर दैन 7 days, ज़्यादा से ज़्यादा 7 दिन के अंदर अंदर. 3 दिन के अंदर पहले तो हुक्म है कि 3 दिन के अंदर जो है ना ट्रायल शुरू होने के 3 दिन के अंदर मुलजिम को तमाम डॉक्यूमेंट्स मुहैया किए जाएँ. अगर 3 दिन में वो मुलजिम को डॉक्यूमेंट्स पूरी फाइल नहीं मुहैया की जाती फराहम नहीं की जाती तो 7 दिन के अंदर 7वां दिन लास्ट दिन होता है. उसके बाद फिर बिफोर द कमेंसमेंट ऑफ द ट्रायल. सेक्शन 265D व्हेन चार्ज टू बी फ्रेम्ड. चार्ज जो है जुर्म जो है फ्रेम कब किया जाता है. इफ आफ्टर परसुइंग द police report or as the case may be the complaint and all other documents and statements filed by the prosecution, the court is of opinion that there is ground for proceeding with the trial of the accused. It shall frame in writing a charge against the accused. इसके आगे आ जाता है जी दफ़ा 265 E. प्ली. नंबर 1, द चार्ज शैल बी रीड and explained to the accused and he shall be asked whether he is guilty or has any defense to make. The charge shall be read. जो जुर्म होता है वो पढ़ा जाता है and explained to the accused और accused जुर्म मुलजिम से वजाहत तलब की जाती है कि वो इसने ये जुर्म किया या नहीं किया. उससे पूछा जाता है उसके डिफेंस के लिए. इफ़ द अक्यूज्ड प्लीड्स गिल्टी, अगर मुलजिम गुनाहगार होता है, द कोर्ट शैल रिकॉर्ड द प्ली एंड मेक इन इट्स डायरेक्शन कन्वेक्ट हिम देयरइन. सेक्शन 265F एविडेंस फॉर प्रोसिक्यूशन. इफ द अक्यूज्ड डज नॉट प्लीड guilty or the court in its discretion does not convict him on his plea, the court shall proceed to hear the complainant, if any, and take all such evidence as may be produced in report of the prosecution, provided that the court shall not be bound to hear any person as complainant in any cases in which the complaint has been made by a court. Number 2, the court shall ascertain from the public prosecutor or as the case may be from the complainant and the names of any persons likely to be acquainted with the facts of the case and to be able to give evidence for the prosecution and shall summon such person to give evidence before it. Number 3, the court may refuse to summon any such witnesses if it is of opinion that such witnesses is being called for the purpose of vexation or or delay or defeating the ends of justice, such ground shall be recorded by the court is writing. Number 4, when the examination of the witnesses for the prosecution and the examination, if any of the accused are concluded, the accused shall be asked whether he means to adduce evidence. Number 5, if the accused puts in any written statement, the court shall file it with the record. Number 6, if the accused or any one of the several accused says that he means to adduce evidence, the court shall call on the accused to enter on his defense and produce his evidence. Number 7, if the accused or any of several accused, after entering on his defense, applies to the court to issue any process for compelling the attendance of any witnesses for examination or the production of any documents or other thing, the court shall issue such process unless it considers that the application is made for the purpose of vexation or delay or defeating the ends of justice, such ground shall be recorded by the court in writing. Section 265 G. Summoning by prosecutor and defense. Number in case where the accused or any one of the several accused does not adduce evidence in his defense, the court shall on the class of the prosecution case and examination, if any of the accused shall call upon the prosecution to sum up his case, whether the accused shall make a reply. Number 2, the cases where the accused or any one of the several accused examines evidence in his defense, the court shall, on the class of the defense class case, call upon the accused to sum up the case, whereafter the prosecutor shall make a reply. 265 H. 265 H. Acquittal or conviction. Number 1, if any case under the chapter in which a charge has been framed, the court finds the accused not guilty, it shall record and order of acquittal. Number 2, if in any case under this chapter the court finds the accused guilty, the court shall, subject to the previous provisions of section 265, pass a sentence upon him according to law. 265 I. Procedure in case of previous conviction. In a case where by reason of a previous conviction the accused has been charged under section 221, subsection 7, the court, after finding the accused guilty of the offence charged and recording a conviction, shall record and the plea of the accused in relation to such part of the charge. Number 2, if the accused admits that he has been previously convicted as alleged in the charge, the court may pass a sentence upon him according to law. And if the accused does not admit that he has been previously convicted as alleged in the charge, the court may take evidence in respect of the alleged previous conviction and shall record a finding therein and then pass sentence upon him according to law. 265 J Section 265 J statements under Section 164 admissible. The statements of a witness is duly recorded under Section 164 if it was made in the presence of the accused and if he had notice of it and was given an opportunity of cross examination. The witnesses may, in the direction of the court, if such witnesses is produced and examined, be treated as evidence and in the case for all purposes subject to the provisions of the Evidence Act 1872 1872. Section 265 K Power of the courts to acquit accused at any stage. कोर्ट को ये पावर हासिल है कि वो मुलजिम को किसी भी स्टेज पर बरी कर सकती है. Nothing in this chapter shall be deemed to prevent a court from acquitting an accused at any stage of the case if, after hearing the prosecution and the accused and for reasons to be recorded, it considers that there is no probability of the accused being convicted of any offense. Section 265 L Power of Advocate Generals to stay prosecution. At any stage of any trial before a high court under this code, before the sentence is passed, the Advocate General may, if the think fit, inform the court on behalf of government, and he shall not prosecute the accused upon the charge, and thereupon all proceeding against the accused shall be stayed, and he shall be discharged of and from the same, but such discharge shall not amount to an acquittal unless the presiding judge otherwise directs. 265 M Time of holding sitting. For the exercise of its original criminal jurisdiction, every high court shall hold sitting on such days and at such convenient intervals as the Chief Justice of such court from time to time appoints. 265 N Plea of holding sittings. Number 1, the court shall hold its sittings at the plea of at which it held them immediately before the commencement of the law reforms ordinance 1972 or at such other place, if any, as the provincial government may direct. Number 2, but the High Court may from time to time, with the consent of the provincial government, hold sitting at such other place within the local limits of its appellate. jurisdiction as the High Court appoints. Number 3. Such officer as the Chief Justice directs shall give prior notice in the official gazette of all sitting intended to be held for the exercise of the original criminal jurisdiction of High Court. आज तक के लिए बस इतना ही। मिलते हैं इंशाल्लाह कल एक नई वीडियो के साथ। अगर वीडियो अच्छी लगी हो तो जो मेरे नए आने वाले दोस्त हैं वो मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें, और ताकि मेरी आने वाली हर वीडियो आप तक आपको नोटिफिकेशन मिल सके और आप इससे इस्तेफ़ादा हासिल कर सकें। अल्लाह आपका हामी नासर हो। अल्लाह हाफिज़।